Okay, so we'll start with just introducing ourselves and get into things. And as people come in, they can catch on. This is also being recorded, and I know it's going to be on the Houston Young Lawyers Association YouTube site, so people can catch up there as well. So my name is Estelle Hebron-Jones, and I'm with Texas Defender Service. I'm here with Helen and Cassie, who will also be presenting, and we do parole work, and we're going to tell you the ins and outs of doing parole work and how you can get involved with doing it. I think at the end of this session, it'll really provide you with a strong foundation for it, and we'll also talk about TDS's pro bono parole network as well. Cassie, how about you? Introduce yourself.
Hi everyone. Thank you for being here today. My name is Cassie Geiken. I am a parole attorney with Texas Defender Service, and I'm excited to be talking about all of this today with y'all.
Hi, I'm Helen Gaebler. I teach at the University of Texas School of Law here in Austin. I teach a class in reentry, and I also supervise a parole pro bono project that is part of our Mid-Hoff pro bono program. I also wear a second hat assisting TDS with the development of their parole work.
So just to give a little bit of the agenda, so I'm going to talk a little bit about our pro bono parole network. We'll go into how the parole process works. Then we'll have a portion of ethics, which we'll be talking about specific ethical rules and how they might apply in certain things you may see in parole representation. Then we'll talk a little bit about the resources and support for attorneys and answer any questions people have. You can send questions throughout our presentation if the question is relevant to what we're talking. If the question seems like it's best to be answered at that moment, we'll answer it. If not, we'll answer it at the end. And so just to introduce the network. So our network, it's an informal network, mostly of firms and attorneys who take on cases that we screen and send out to folks. There, as being part of the network, you get access to materials and resources like templates and client interview guides and a whole bunch of things. It's a site just for people who are doing this work with TDS. So it's not for people who are taking on work for private parole clients. But along with if you take cases with us through our network, you have a case mentor, which would be one of us who can, if you have any questions that come up throughout your representation, we're there to support you. But with this CLE, you don't have to, you can, whatever you learn, you can go off on your own and use it from the CLE, but access to those materials and that support that's being part of the network. And what we want in return is we'll ask some questions about like your experience during the representation, and help us gather some information about what's happening in certain parole offices, so we can just learn more about what's happening across the state. But we'll get into that more later.
All right, so why do this work? I started doing this work 8 years ago. I'm not a criminal law attorney. I've never done criminal law. I've done a lot of other types of civil law in the past. And it is actually one of our law students who brought this work to us here at the law school and suggested it would be a great opportunity for pro bono work. So I've been running the pro bono program here at the law school for 8 years. And I have to say it is absolutely, from a very selfish standpoint, probably the most rewarding work I have ever done. I think for our students, it has been incredibly rewarding across the board. Cassie is one of our former student attorneys. And what makes it so rewarding is that it is impactful in terms of outcome. And you'll see here our rates at the law school and at TDS as well. I mean, and across really with anybody I know who's getting representation in these proceedings, is a much higher success rate, not surprisingly, than if you are just being reviewed by the board solely on the paper. And by paper, I mean basically your criminal history records and some of the paper that shows what you've done inside TDCJ. What we do is we really can humanize and contextualize the scenarios that have landed people in prison. And I think some of our clients have in the past been concerned about, they don't want to make excuses. And so we're very cognizant of that. And what we tell them is it's not about making an excuse for choices they may have made or actions they may have taken. It's really about putting those actions and choices in context and letting the board understand the full picture of that person's life, their life circumstances, what was happening to them at the time of the offense for which they're serving a sentence, and really understanding changes in their mindset, what has worked for them while they've been incarcerated, and what is going to ensure that they can succeed this time on parole if they have had troubles in the past on parole. We want the board to really understand the whole picture and understand those range of resources that we can help gather for our clients. The other thing is it is just empowering for the individuals we serve to be heard and to have a voice in the process. I think if you talk to people who have been incarcerated, you'll hear frustration with not understanding the system, not feeling like they have a voice, feeling like it's completely arbitrary in terms of who gets paroled and who doesn't. And what we can do is also help educate our clients about the process and help listen and help give them the voice that they so desire. Because in Texas, without representation, they don't have any direct access to the board. We have access to the board in ways that an individual who's incarcerated does not. So with that, I encourage everyone to do this work. It is not super legally technical. It doesn't matter what area of law you practice in. It's really about telling somebody's story.
Yeah, you can go to the next slide. Great. I want to start us off today by just going through what the parole process in Texas is. And today we're only talking about the administrative parole review process for people who are currently incarcerated in Texas, who are trying to get out. We're not talking about revocation. You may have heard about parole hearings that happen if someone is out on parole and then they get arrested and they're waiting to see whether or not they'll be released again. So we're just talking about people who are currently incarcerated in TDCJ in the prisons in Texas. And here it is an automatic administrative process. It's not something that people apply for or request. It happens automatically after they have served a certain amount of time on their sentence. It's typically a quarter or half, depending on the person's offense, and if they've had any major disciplinary infractions that have messed with their time. The first time that someone comes up for parole, they enter review 6 months before their eligibility date, which is the date the parole board is supposed to have a decision on someone's parole. And once they enter review, they receive what's called a parole interview. This is done by the institutional parole officer, or IPO. This is an employee of the parole board, but it is not someone that votes on their case. It is not a sitting member of the parole board who is making a final decision. The first time that someone is reviewed, the interview with the IPO might be a bit more involved, maybe 20 to 30 minutes long, but it is generally interrogative in nature. Oftentimes they focus on someone's past drug history or their criminal history, not really going outside of those two things or getting context like Helen was talking about on why certain events have happened in someone's life. For any subsequent parole review, however, that interview is usually extremely brief, and is oftentimes just the IPO confirming specific details with a person. They're generally no more than 5 minutes long and may be a set of a few yes or no questions or confirming an address, but nothing more than that. As an example, a past client of mine, it was her third time coming up for parole. The IPO came up to her in a hallway, asked her a couple of yes or no questions, had her sign a piece of paper, and that was her parole interview. And after this interview, that is when the IPO drafts what's called a case summary report, and they submit it with the entire case file to the parole board. It's important to note that these reports are not deemed to be public documents, and they are not disclosed to the individual or their attorney if they have one. So there's no way to actually verify that the information in those reports are accurate. And moreover, to the best of our knowledge, we believe that the IPO is the one that calculates the individual's risk score. Going through a risk assessment, they're the ones that calculate that. But we will talk about that a little bit later in this presentation. We also believe that they make a recommendation to the parole board about a final outcome. But again, that's not something that we can know for sure because we are not allowed to see the case summary reports. They send off this case file to whichever board office is in charge of the unit that the individual is in. Texas has 7 regional parole board offices. Each are assigned to specific TDCJ units. Each of these board offices has 1 board member who is appointed by the governor and 2 commissioners who are hired by the board's presiding officer. The 3 individuals in each board office constitute the voting panel for that office. Almost all of the board members and commissioners have backgrounds in law enforcement or they have worked in the prison as former correctional officers or parole officers. The vast majority of them do not have a legal background. When the board receives the IPO's case file, a lead voter is assigned to the case. It could be any of the 3 members of that voting panel. The lead voter reviews the case summary and they speak with any potential objectors. These would be victims, judges, prosecutors in the original case. The board is required by statute to grant requests to meet with any victims or institutional stakeholders. The same is not true for the parole eligible person. They do not have a right to speak directly with the lead voter or any of the voters in their case. Family members or supporters or their attorneys can ask to speak with the lead voter, but the board has full discretion regarding these requests. And if you are not an attorney, they do typically deny that request. When we request to speak with the lead voter, it is still fully at the board's discretion. They do not have to say yes, but there is an unofficial internal policy to always grant attorney requests to speak with the lead voter. In the 7 years that I've been doing this, I have never been denied, nor have we really heard of anyone being told no when they request a hearing. So then after the lead voter reviews the case file, meet with any objectors, meets with the attorney, they cast their vote. The case file and any interview notes then pass on to voter 2, one of the other 2 members of the panel in that board office. If the second voter agrees with voter 1, that's the decision. It's final. If they disagree, the case file passes on to the 3rd voter for a tie break. This is not the usual what people think is happening in these parole board reviews where there's 3 members of a panel sitting and all talking about cases together. Usually they're making decisions independently, and oftentimes whatever the first voter says is usually what the second voter says as well, especially if the first voter says no. And it's worth noting that annually the board votes on tens of thousands of these cases on top of all of their other work. They are making decisions about several other types of cases. And so that means that there are 21 people in the state voting on these cases. And so in most instances, they have just a couple of minutes to make a decision that will have a significant and lasting impact on someone's life, as well as the lives of their family and their children and all of their other supporters. And so that's why representation is really important, because then you have those hearings where you get a little bit more time to have that lead voter looking and thinking about a case and hearing context for the first time. So we can go to the next slide. The next part of this presentation is we want to walk you through a sample timeline of how we and our network partners at law firms have done our representation. There's 8 basic steps to doing parole representation. It's just a sample timeline. It's not how every attorney in the state does this work, but we found that this works pretty well. And you'll see as we go through that this work is not highly burdensome. It does not require any criminal law expertise. It is an administrative process that requires an attorney for the full advocacy opportunity. Without an attorney, there's no hearing. Someone's case does not get fully seen by the board or fully understood by the board. When each of these steps happen, it is dependent on external factors outside of your control. There are some issues and delays in the process that will come up. We'll mention them as we go through each of the steps. We have estimated that for an attorney who's done a few of these cases, it's typically 30 to 40 hours of work over several months. So it is not a ton of work. It does take a few cases to kind of get in the swing of things and fully understand the process. But it's a few hours of work here and there just over the course of a few months. And the first step of that is client identification, something that our pro bono partners do not have to do because we do that at TDS. We identify clients through people who reach out to us or their supporters, from our partners who are reentry advocates in the state, and by contacting people ourselves who we think may be lacking support in the free world. For attorneys in our network, this means that we have clients that we will refer to you. These are all people that we have sent surveys to so we can get a better understanding of their case. Our survey asks them about their criminal history, what they've accomplished in TDCJ, and their plan for release. These surveys are very important to see information that's not just publicly available criminal history information. Someone is always much more than their offense, and there's always context for that offense. The parole board makes snap judgments like that based on that information. So it's very important that we don't, and we ask that our partners don't make the same snap judgments when we refer them cases. So if you take on a client, you will receive a copy of their survey along with a memo kind of taking you through the basics of their case. Steps 2 and 3, getting TDCJ clearance. TDCJ is the Texas Department of Criminal Justice. They are the entity in the state that runs the prisons and client onboarding. Those happen at the same time, and you can do those immediately upon getting a referral from us. TDCJ clearance is getting a representation form and a fee affidavit submitted if there are any non-attorneys that are working on the case, because through UT, we have students working on the case, or paralegals will sometimes work on cases. Non-attorneys are absolutely free to work on this case. You'll submit authorization forms for them, and these forms can usually take about 1 to 2 weeks to process. And so while you're waiting for that, you can reach out to your client. We do this in 2 ways. The first way is through an e-messaging service called Securus. It's fast, but it's not confidential, but it is a way to have quick communication with your client. We'll use this to introduce ourselves and establish a communication pattern, let them know when we're scheduling a call or a visit with them. And then we will also communicate with them through legal mail, sending mail directly to them at their units. We'll mail them a representation agreement saying that we're limited to just doing their parole case for them. making a parole packet and representing them at the hearing, that we can't assist them with other things. And we'll mail them a set of releases so we can get their documents, get general release to get their criminal records, a HIPAA release for medical records, and FERPA releases for educational records. Just so you're aware, there are some delays happening with legal mail. So sometimes we will wait until we have our first visit to have them fill out all of that paperwork. It just depends on when the attorney can schedule that initial visit with the client. The next step is to have that in-depth interview with your client for the first time. However, before we talk about what that looks like, I do think it's important to understand what the parole board is looking at when they review a case, because that informs what we gather from the client during the initial interview. Thank you, Estelle. So we know that the parole board is looking at that case summary report. It also includes police records, court records, something called the individualized treatment plan, which is programming that someone is told they should do while they're incarcerated. They'll also see TDCJ records. That includes their disciplinary history inside and all things like that. But we know that the board only has a few minutes to go through all of those records and the case summary report. So how are they managing all of that information? They rely on this risk assessment that is set out on this slide. It takes into account both an individual's risk assessment score and the assigned offense severity class of the underlying offense for what the person was convicted of. The offense severity class is a set score just based on the offense. So obviously those higher level offenses have a higher score, lower level offenses have a lower score. The risk assessment instrument is made up of these static, unchangeable factors and dynamic, changeable factors. Each of these factors is assigned a point value and are added up to calculate what the board sees as a person's likelihood of success on parole. And based on that calculation, each person is determined to be low, medium, high, or highest risk for parole. This score, this low, medium, high, highest, is combined with the offense severity class, and it pops out a parole guideline score, 1 through 7. 1 means the person has the highest risk. They see them as being the least likely to be successful on parole. 7 means that the board sees them as having the highest chance of success, the lowest risk. Each of these scores has a recommended approval range. Level 7's at 65 to 100% of those people should be approved. Level or score 1 has 0 to, may not be remembering, I think it's about 12%, something around there. So obviously if the board determines you to be a lower risk, then you should have a higher chance of making parole. This score, however, is hidden from the parole eligible person and their family and their attorney. We cannot review the case summary. We can't review the matrix data or check for errors. We just have to trust that the very short yes or no parole interview, that the records that the IPO is reviewing, that all of that information is correct and accurate, and it was enough for the IPO to run this risk assessment. This score we know is used as an aid for the board. What it does help us understand, though, is what the board is concerned about. Past revocations from supervision, either parole or probation, long criminal histories, disciplinary infractions. And we know that through the score, they're seeing those factors just without context. So going back to that initial interview, that is what we are doing. We are gathering context. We try to do interviews with clients in person, but confidential phone calls are possible. These are no contact confidential visits, which means generally it's you and your client are on opposite sides of a thick glass plate. We tend to just use pen and paper in these interviews, but you can sometimes bring in laptops or tape recorders to help you run the interview. This first conversation with your client is usually about 2 to 3 hours long, where you're not trying to get all of the information from someone's life, but everything that you need to get started with the case, start putting together a narrative, everything you need to get all of their documents, and contact all of their supporters. These interviews require us to go deep into someone's history, including their trauma. So we do, I think Estelle will talk about this in a bit, but we do think it's important to be trauma informed during these interviews, and come from a non-judgmental space, because we go through everything from their family history, other personal history information like relationship history, past abuse experiences, if they have children, what their life was like growing up in high school as a young adult, really building the base for talking through their criminal history to help identify patterns and reasons for their decision making, and to explain why they'll be successful coming out in the future. This is when we'll collect more contact information for their supporters, build out a timeline of their criminal history with context, ask about their substance use. That is something that the board is very concerned about. So we want to build out a timeline of their use and talk about their recovery. We'll also cover mental, behavioral, and physical health histories to see if there's anything relevant there to share with the board. When talking about their current incarceration, we go through things they've gained from programs, from school, from work, if they've had any big important events happen while they've been incarcerated, or received any disciplinary infractions. And finally, we will talk about their plan for coming home, their reentry plan. That's housing, transportation, employment, financial support, emotional support, recovery support, all of that stuff. And not just one plan, but building out a plan A, B, and C with them during these interviews. And it's in that last point that we also discover what clients are lacking in support, who doesn't have a robust reentry plan, and we can help connect them with resources that they can rely on when they're coming out. So that's step 4. I will pass it off to Helen to do the back 4 steps. But please, if you have any questions about any of that, because I just kind of talked at you for a while, please feel free to drop those in the chat.
Thank you, Cassie. So the back 4, right, you now have done your initial interview, which is pretty in-depth with the client. You're going to hear a lot of, information that you think trying to understand more fully, and just wanting to make sure that everything you're hearing is as accurate as possible and as complete as possible. One of the things you'll learn is that with individuals who have experienced a lot of trauma, and all of our clients have throughout their life, often memories are not, fully intact. And so trying to fill in gaps with records and just make sure you have the right dates and the right sequencing of events can sometimes be a challenge. So we try to collect as many records as we can, both to just fill in those gaps, confirm areas where we have some questions, make sure we really are understanding what's going on, and that, these are administrative proceedings, and so it's quite informal. It's not like going into court and having to prove everything up with evidence, individual, submitted. So it's a kind of different sort of evidence gathering. It's as much for our own benefit as it is for finding things that we're going to use to submit with the packet or provide to the hearing officer. So we always want to get what's called a TDCJ pen packet, which will have their time computation forms, their disciplinary history, with some minor details around that. Educational records from the TDCJ Wyndham School District. We now also will get if they're using their tablets to take classes, we can get a code from our clients to download transcripts of those classes. We will also, as Cassie said, if we have clients who have significant medical issues, we want to make sure we have some documentation of those health concerns, and also see how we can use that in the packet, either in clients who have been asking for medical care and not receiving it, or they're receiving inadequate care, where maybe if they were in the free world, they would be able to get much better care to really better resolve their medical issues. And so those are the types of records we're looking for. I think we have a slide, Estelle, that has kind of what those. Yeah, so these are the types of things to request. We very specifically have all the information about where to send the request, the type of information you're going to be asking for from each of these. And not every one of these will be sought in every case. It really is going to be case specific, whether we've had clients who have extensive criminal history records. We want to make sure we have a better sense of kind of the timing and the sequencing of those. We'll sometimes ask for police reports in those cases. Other times we have a client where their criminal history is really very minimal. We're not going to search out police records or court records for that person. So it's very client driven. The records will take a while to get. Sometimes the TDCJ records come pretty quickly. The other records, you may have to follow up and make a second request. It could take a month. Often while the records are waiting. And if we go to the next slide, Estelle, we're going to be doing some of the other steps that are needed to have a complete parole packet. Collecting letters of support is a second sort of key area. This can also take some time. We often have to text, and then we'll also call, and we'll also write an email if we have that contact information, to have family and supporters respond to us. We want to think about letters of support almost like witnesses. I think there is some belief amongst individuals who are inside prison that the more letters they have, the better they are. They'll show, if they can have 20 people write to say, Joe's a great guy, he's going to do really well, he should be on parole, like that's going to be helpful. It's actually not that helpful. The board sees those letters all the time. What we're aiming for in our letters of support is to identify individuals who can provide concrete, specific information about maybe verifying bits of the person's past history, providing more confirmation and contextualizing of incidents that were happening at the time. Many of our clients have had a lot of significant trauma right before they engage in a criminal activity. And so sort of understanding some of those links and some of those that context is really critical. We will have people write about if they've been in contact with the client throughout the period of incarceration, changes they've observed in the person's mindset, conversation, topics of, their goal setting. They're talking about classes they've taken. What is it that the person can help the board understand better about how this person has really grown and changed while incarcerated. And then the other letters of support are from individuals who, as Cassie said, what does the reentry plan look like? Is this a person that the individual is going to go live with when they come out? Do they have a job they can offer? Do they have financial support they can provide? Whatever they can offer in terms of support, we want the board to know and hear from the person individually confirming that support. We then have all the records. We have letters of support collected. We also want to get a letter from the client, him or herself, in terms of what they're going to tell the board. If they were sitting in front of the board, what would they want the board to know about them, about their history, about who they are today, and who they want to be in the free world. We guide our clients in terms of what goes into those letters, and we help ensure that they are as specific and comprehensive as possible and address what the board is really going to be worried about for this individual. We also collect from the individual who's our client or their family members certificates, whatever additional information they might have, photographs. We've had clients provide us with poetry or drawings or things that they've created while inside. Letters that they've sent to their, we had a client who had kept a diary for a journal for their child, that we had sort of submitted pieces of that. So you never know what your client may have that will help the board understand, again, sort of humanizing the client and helping the board really understand who the person is today and not be so focused on what happened in the past, but allowing people to move past their histories and to create a new future for themselves. Once we have all that information, we draft the parole packet. That is actually probably one of the quickest and easiest steps. These are short. We don't go more than 10 pages. That includes a couple of pages of like an introductory cover letter that really highlights, here are the top 6 reasons why this individual should come out on parole, why they're going to be successful. We provide a narrative section, and then thank you, Estelle. And then here we have the 10-ish pages. Really, it's a mitigation document, providing some of the history, the personal history, the context, what information we think is critical for the board to know about this particular individual and why remaining in prison is not helpful to that person, and it's not helpful to public safety, and it is not helpful to the citizens of Texas. That really it is time for this person to come home, and they are going to be much better served, and the community will be better served to have them home. And then the exhibits, and there you can see the types of exhibits that we oftentimes include. Some of these we always have, and some are going to be client specific. Okay, next slide. And finally, it's the parole hearing. We will prepare for the hearing, creating the hearings are, let me back up. The hearings are very informal. The board does not even call these hearings. They call them interviews. And so we have the opportunity to speak with the individual, the person who is designated the lead voter on a case. That is one of the 3 members of the assigned board office. That is the only person we get to speak with. We don't speak with all 3 voting members. So we meet with the lead voter. We submit a request early on. As soon as the person goes into review, we submit a letter to the board office saying that we're representing the individual and that we're requesting an interview with the board's lead voter. As Cassie said, we are always granted those. Attorneys, as a matter of practice, if not rule, are always granted hearing interviews with the lead voters. That is not the case for family members. They can ask for an interview. They're almost never granted. And so that is one of the real benefits of having attorneys representing these individuals, is that we get, as Cassie said, that extra time in front of the lead voter to really help them focus on the case and on the individual in front of them. So these are administrative in nature. We can offer up a lot of evidence that we would not be able to offer up in a court setting. These are quite flexible, and the board is eager to have information presented. We will often almost always bring somebody with us, one of the supporters. I usually like to bring the person who is going to be housing the individual. I think it's important for the board member to see that person And just to sort of, again, it makes it real for them to see the actual individual. They don't see the client, but they will get to see somebody who is in touch with the client, who can vouch in front of them for the client, and who will vouch for what they will do on behalf of the client when they come home. These are short hearings. The board has recently issued a ruling saying that they want these to be 20 minutes. We have historically always gone 30 minutes. We tried to keep them short and very direct. The board members don't have much time. They get antsy. They really want to hear new information, detailed information, and then, jump in, jump out, be very direct. Even with the 20-minute rule, our understanding is that attorneys have been granted additional time. It's really up to the individual voter to decide how much time they want to grant. But I think what they wanted to get away from were hour-long, hour-and-a-half-long interviews. They want to keep these short and succinct. And so as long as you are giving them good information, they will let you keep going. But really, it's that 20 to 30-minute sweet spot that we're aiming for at this point. I always do these hearings on Zoom. You can do them in person. I know people who always do them in person. I find it I don't see any real difference in the outcome between Zoom and in person. And I like Zoom because it allows us to have the family members or supporters there with us. Travel is hard for a lot of people. These are, the board offices are not close by, in most cases, where the family lives. And so to have them be able to participate by Zoom has been very helpful for us. And so that is pretty much it. Once the hearing is over, you will usually get a decision very quickly within anywhere from 48 hours to 5 days is typical. Sometimes it goes as long as 10 days. Often, I think that's because of vacation schedules, or people are sick, or it has to go through voters. There's all sorts of reasons we don't know about. But by and large, it's kind of 2 to 5 days. You'll get working days. You'll get a decision. You don't get notified directly from the board. You have to just keep checking the TDCJ website to see when a decision drops. And decisions are not just an up and down vote. It's not yes or no. It's yes and or no. And how long is until your next offset. So for the yeses, you can see these here, voting options on the left-hand side. You can have yes, like an FI1 is what everybody dreams for. It's you're going to get released as soon as you're eligible, which means as soon as you've been processed. You don't have to take any more classes. There's no mandated coursework for you to complete. You can just get out. Usually that still takes about 60 days. So you need to prepare your client and families for that. But a lot of the decisions are also some kind of delay. They want you to take a class, or you can be released without a class, but not until next September. We want you to serve an extra 4 months inside. There can be a lot of different outcomes for what that delay looks like. And again, that's a matter of preparing your clients for what to expect once that decision drops. They really don't get any direction in their decision other than what's here. FI1, FI2, FI3R, they'll be told you need to take a class, but they don't even know what the class is necessarily at that point. And so there's a lot of uncertainty and vagueness around the decisions that come down from the board. But I just want you to take away is that there's a whole range of what these decisions can look like. On the denials we have here, they give the reason for the denial. For example, many of our denials are D1, D3, D5, criminal history. There's drug or alcohol involvement or history of substance use, and maybe there was a revocation from some past period of supervision. That's a very common combination of denials. The board will then say when the next hearing is going to be. Typically, it has historically always been 1 year set-offs. The board is, in particular, with intoxicated manslaughter cases. The last legislative session, there was a push to lengthen those set-offs to make it more of a 2 to 5 year set-off for a lot of offenses that might have historically had a 1 year set-off. There's a lot of reasons for that. But the denial will also inform when the next hearing will be. And with that, I think it goes to you, Estelle.
Yeah, so I'm going to talk about some ethical considerations in parole representation. And, and then if anyone has, questions that come out of it, anything you've heard, you can drop them in the chat, or I guess you can also raise your hand. I think there was the allow to talk function. And so yeah, so as I go through this, if anything comes up, just bring our attention to that. So, there are lots of different ways in which the ethical rules can apply. So, but I just have a selection here, some things for you to consider and some situations and that might, where you might see these things come up in. So the first is Rule 1.01, competent and diligent representation. A lawyer shall not accept or continue employment in a legal matter which the lawyer knows or should know is beyond the lawyer's competence. Again, the first part there. So obviously, by taking this course, you are becoming competent in parole representation. But along with that, so once you have a case, some things that you should be doing are like checking the parole board website. So the parole board website, so let me see if I can actually, I will stop this share. And I will share the parole board website. On that site, you can find out, where the regional office is that you're, where your case is coming out of. Let's see. Sharing, okay. And like on this is the Texas Board of Pardons and Paroles website. They have latest board news, which will give you information on, when new board members are appointed, if the chair writes a letter to attorneys saying something about kind of a new policy that they might have. They also have rules and policies and directives, which can be policies. So there's a lot of different things. So keeping up with that is something that you can do to make sure that you're staying up to date on what's happening. You're not going to see a lot of like legislative change necessarily in parole, but you will see policies and rules change that could impact your case. And also then if you're part of the network and you take a case that we refer to you, the access to the mentorship, you are also, confirming that you are getting the assistance of other lawyers who might know more than you. And with that, it's like really just an open line. If you have any questions about anything, you shoot that over. Like, so if I was like your case mentor, I could, if I know something, of course, I'll tell you. If not, there are other people I can consult about what to do. And parole is interesting because, it's not, there are rules, but there are lots of things that aren't quite fixed. And so having access to people who know, who have been exposed to a lot of other cases is really useful. So There's 1.01. Conflicts of interest. So, most of our volunteers are getting cases through like their firms, pro bono coordinators. And so usually you're already, your conflicts of interest have already been checked out. So they shouldn't really be an issue in these cases. But conflict checks do happen. And, you want to be also mindful, like if you had another job before where you might have been representing people who've been affected by the criminal legal system, making sure you're not representing someone in parole who might have been like a co-defendant of someone that you're representing. Because sometimes, even though you want to be forward looking in your presentation to the board, both in the packet and in the oral advocacy portion, sometimes the narrative, when it comes to the facts of a case, might come into play. And so you wouldn't want to be put in a position where you are suggesting something that is at odds with your current client or your former client. But usually those checks are already done before you, not usually, those checks are done before you have the case in front of you. Rule 1.05, confidentiality. So confidentiality that includes both, privileged information, but also unprivileged client information that you're getting when you're communicating with your client, as well as working, getting records. So you're getting health records, for example, and you want to also keep in mind that, when you're working with your client, you're also likely going to be working with, family members of the client. You'll be working with us, and you're going to be taking in some sensitive information. So that could be like health information, but it could also be related to the client's story that they're telling you. And one of the things that we have on our resources website is like a sample engagement letter, which when it comes to, working with TDS, making sure that you have that in your engagement letter, that you'll be consulting with us during these cases, and that we're part of we're not representing the person, we're part of the team, and so we have access to that information. But you also want to, when you're talking with your client, making sure that you are clear about what let's say their mother is the person who you might be talking to the most because that's who your client is planning on staying with afterwards. Just making sure those lines are clear about what your client is okay with you sharing with, like, their mother, because it's not just a complete open door. Like, you still are your representation is still of that client. You're not representing their family or whoever, another party outside. So you want to keep that in mind. And this kind of goes into the client communication rule, where you have to keep your client reasonably informed about the status of the case, and comply with reasonable requests for information. Now, again, like, parole cases are different. While there are like timelines and sort of deadlines, they aren't necessarily the same as when you're dealing with, in litigation, where you have strict deadlines. And also the part about parole representation, as it's been mentioned, you're not necessarily going to know as much as you might know in another type of case you're working on. So with the case summary form that the institutional parole officer provides to the board, you don't know all the information. You don't know when that summary is even sent to the board office. So sometimes you have to be if you want to know some of that stuff, you have to be proactive. And then whether they even tell you, like, oh yes, the report has been sent over, you don't know. So there's like two parts. I think one is reinforcing to your client, and because I think a lot of clients don't know this. They'll think, oh, well, you're a lawyer, so you have access to everything and you know everything. So one is, like, from the beginning, being clear that you don't have pretty much anything that you have access to, your client could have access to. There's no special access. But when you do know things, so like when you filed your packet, when you have the interview / hearing scheduled with the lead voter, those are things you want to make sure you are communicating to your client, so that they can know. I think one of the things also with communication is, when it comes to the result of the parole case. So people think, oh, but what's going to happen is the parole board, they're going to call my lawyer and tell them what happens. That's not what happens. Usually, like when I find out about results of cases, I go on the TDCJ website, where you can search for anyone in TDCJ and find out the results of their parole case. And so that's how you're going to, lawyers, public will find out about stuff. So of course, a lot of times your client will find out before you sometimes. So I think just making sure you can be clear about what your client can, so communicate with them, but being clear about what they can expect to hear from you, how quickly you can reach them. With communication, so it's been mentioned, there are different ways that you can talk and communicate with your client. So one set of ways is through, there's legal mail, legal visits, legal calls. This is the only way to make sure that your communication with your client is protected. So with legal mail, is so if you're familiar with sending mail to prisons, it's basically mail that you mark as, you have to write on it or stamp it with the words legal mail, attorney-client privilege if you're already representing them, because they changed the rules like 3 years ago or so, where only legal mail is only physical mail that can go into units. So marking it is very important to make sure that your client is actually receiving what you are sending to them. Because family and friends, everyone else, have to send mail to a processing center in Dallas, where they scan the mail and they put it on tablets. The other types of legal communication, so legal visits, so that's where you contact the unit and request a time, see if the time is available, and you send in a form with a copy of your bar card, and you go do a visit. And we also, in our attorney resources, we do have guides and instructions for how to do all of this, just FYI. The other way is legal calls, which you can schedule similarly to legal visits. When you are calling or visiting, one of the things you also want to make sure is that, like, your client is, make sure there isn't like a guard, like standing, like, breathing right over them, making sure it actually is, which sometimes can happen. And you can, say, I'm having a confidential legal visit with my client. Can you, please step back? How they might receive that might be different. Or your client might be taking a call in an area where they are not actually, they don't really have privacy. So there's some things to keep in mind when you're communicating with your client. The other way you can contact your client is through a service called Securus. And that's where clients can, basically like emailing, you buy stamps and you use that to send messages. There's no button you can click to say, I'm an attorney, it's confidential. So those are things that when you send it, it's not it's not instantly received by the person you're sending it to. Someone at TDCJ reviews it. I don't know anything about the process about how they review it, how quickly it gets to your client, and it really depends on the day. Most of the time, it's going to be within like a couple days. Or sometimes even I sent something to someone today, they responded to me 20 minutes later. So that's another way you can contact your client, and and I use that to confirm, be like, oh, I'm going to call you on this day, I'm going to visit you on this day. they might send you something like, here, they might say, oh, here's this person's contact details, or just send you random note. But you'll want to make sure to also make it clear with your client what that anything they send is not confidential in those messages. It's convenient, but it can, it's not without its faults. And I think one of the things you want to keep in mind is, especially when, well, depending on the client, they might have certain thoughts or ideas about how they want to like present their parole narrative, which could have implications for maybe like, let's say they have a post-conviction case they're trying to pursue, or like an innocence claim. Just want to keep in mind, like, remind them of what they should and should not put in those JPay messages. Most people do have tablets to receive the messages, but some people don't. And that's like most, now it's more if there's been like a disciplinary issue. Sometimes it could be because the tablet is broken. And in those cases, they print those out for the person. But if they want to get back to you, they have to send you legal mail, physical mail. Okay, so when it comes to the scope and objectives of representation, so, of course, the general objectives are guided by the client. However, the strategy is still, just like any other case, is still something that the attorney is responsible for. And so there are a few different ways in which you might kind of bump into something related to this. So, and so just generally when it comes to like the scope and objectives, going back to that engagement letter, it's really important to be clear with your client about what you are actually doing for them. Like you are representing them in their, September 2026 parole hearing. This is what you'll do. This is what you'll not do. But when it comes to putting together the packet, and thinking about what you want to put in there and how you want to be most effective, let's say you could have obviously the objective is your client wants to be released on parole. But a client could say, you know what, I want to send a letter to the DA asking them if they will, agree to say that they don't object to my parole, but you don't think that's a good idea. And in most cases, that won't be a good idea, but you don't think it's a good idea. And like, especially considering the facts of your client's case, probably not a great idea. Or your client wants to say something in a letter that is not truthful, or say in their letter, this could be something that can come up, talk about how they are innocent. And you'll have to talk through it with your client about how, like, why they may or may not want to do these things and how it can affect the outcomes of their case. But also you can decide, like, strategically what you want to include and not include. And just make sure that going again with that communication, just being clear about what to expect. Candor to the parole board or the tribunal. So, a lawyer shall not knowingly make a false statement of material fact or law to a tribunal. So even though the parole board is not a court, parole decisions are still, adjudicatory in nature. And so things that you don't want to do, like misstate offense facts, mischaracterize disciplinary history, inflate kind of the courses or the programs that they have participated in, or imply something that's not supported by anything that you have learned. And so like, it's like we're like saying, oh, they're going to go stay with so-and-so person, but that person has never actually agreed to do that. Or, in the, like, let's say you have a client who they were convicted with 2 other people, and in the trial, there was a trial, and your client was the shooter, said to be the shooter, and you say, like, they weren't the shooter. I don't know, something like, you can't mischaracterize those facts as well. And this candor also applies to the support letters that family may write, or potential employers may write, or any community support. So like, let's say you do have a religious leader writing something, you don't want to have something in your presentation where someone has said, so and so prays with me every day, and we talk about we do Bible study regularly, when this person doesn't even know your client. You don't want things like that in there. So and other than it being your ethical obligation not to do that, the other thing to remember and to keep in mind is that you don't know what the parole board has in front of them. And so you're sticking to what you, like, kind of most objectively is going to be the best way to make sure that you're not misrepresenting anything that you're in anything that you present to the board. And then it comes to terminating representation. I think, as always, you want to make sure you protect your client's interests. And so really, this, like, we've never had cases where people have had to, like, decline or terminate in the middle of something. But of course, if that was something that came up, you'd have to make sure that you did make sure that your client was left in a good position. You wouldn't want to register to represent your client and then just disappear. I think that does not show favorably. That could end up just reflecting poorly on your client or former client. Again, going back to that engagement letter, you want to make sure it's clear what's in what your relationship is going to be like, and that between, like, both, it's not just like we're going to, if part of that agreement, you're also telling your client the only way this is going to work is if you are candid with me, and and for us to work together. Because really, with parole, like, you have to work together with your client to really make it work. If you have a client that is not trusting you, not participating, you're not going to be able to put something strong together. But I think some of the things to consider when you're representing someone and when you've finished representing them is making sure that they have a copy of the parole packet that you sent, for example, that you're clear about whether you are, like, so let's say you represent someone and they were denied, and an issue that comes up is, okay, are you going to represent me in my next review? And so, and that's all up to you how you do your engagement letter, but you think being clear from the outset what you'll do. I think, and with our case at TDS, we will continue representing people, especially once you've put together a good parole packet. Kind of the next, if you set off for a year, that next year you're not going to have to put together like a whole new packet. A lot of times you'll be, kind of updating what the client has done in that year, or if there's like been a change to the reentry plan, updating it, but kind of just reaffirming what's in there. The other thing that comes up kind of after representation, so let's say someone is approved for parole, making sure you're clear with them about what you will do after they have been paroled. So if they call you and ask, oh, help me get this, help me get that, but you have in your engagement letter, you point to like kind of, once you've reached this stage, our representation is over. Obviously, if you want to continue assisting someone, you can do that. Going to now about healing informed interviewing and parole representation. And so, but before I do that, I'm going to just pop in the chat the bar course number, because I can't announce it because it's going to be going onto YouTube. I see. Oh, let's see. So I see, Helen, you've been answering questions there. Okay, thanks. So with healing informed interviewing, also called trauma informed interviewing. So what does it mean to be trauma informed? So everyone who's incarcerated has, experienced some form of trauma. Can be caused by lots of different events, including childhood, personal relationships, major life events, interactions with law enforcement, things that happen during incarceration, and it can be something physical, but it can also be emotional, generational, racial, or environmental. So the key principles of healing informed or trauma informed interviewing are, really recognizing the potential impacts of trauma on physical, emotional, and behavioral responses, and then shaping the conversation with your client to build safety and trust, and collaboration, and ultimately empowerment. And how this might show up when you are working with someone is, could be disassociation, and could be withdrawal. It could be some kind of physical pain, like a headache. It could be becoming anxious or excitable or angry. And also could be in the form of experiencing memory gaps or avoiding answering questions, or minimizing what happened to them. So, there are some, do's and don'ts, which we have this also in our resources, things that you can just like think of. So some do's, you want to be transparent. When you're meeting with a client or talking to a client, so especially that first meeting with a client, there is this power imbalance. So, obviously coming in as an attorney, you aren't incarcerated. You want to minimize that. Obviously it's there, but you just like be honest about like who you are, the extent of your representation, and what you do and don't know. You also want to, when you ask questions, explain your purpose, like why you're asking the questions. Tell them, this is something, for example, the parole board will be concerned about or want to know about. So really just giving context to those questions. And you also want to be aware of your client's comfort level. So just being observant when you are interviewing them and speaking with them, telling your client that you can come back to certain topics if they're not comfortable talking about it at that moment. And, if they need to be emotional, giving them breaks to do so. And especially for that, first interview, we recommend it being in person. So going to the unit, so you can really help to create that relationship with them. And when you have your other, you can visit them again, but when you also like talk to them on the phone and so on, like you have this like strong foundation of having been able to connect with them in person. And we recommend those like a longer, plan on being with your client for at least a couple of hours for that first visit, really to get a lot of information. And even then you might not, because you're still getting to know them, you might not get all of that. You're not going to get everything you need. That first interview is often going to be getting to know each other, getting some initial information, and then when you get records and talk to people, you go back with that. Now, when it comes to don'ts, you want to try, you don't want to be accusatory, you don't want to ask closed questions, and you don't want to make assumptions about their life and character and make it seem like you are judging them. The other thing you don't want to do is use alienating terminology. So like criminal, inmate, felon, things that categorize and reduce your client to just a simple, like to one act. And the other thing is you don't, and this is something that's used in a lot of different areas, but not filling silence. So a lot of times in those, taking time for your client to finish a thought or remember something. And so sometimes you can just allow, give them some time to think about their answer and what they want to tell you. And what are the benefits of this? I think it's kind of obvious, but really, we want to get accurate and complete information, but also you don't want to re-traumatize your client, and you want to build rapport and trust ultimately. And how does this support your ethical obligations? It really aligns with those duties of competence and diligence. If you are interviewing a client, or you have a client who is not comfortable with you, they might not share everything that might be useful to you. Like even, there are clients who, if they don't know you, they might not, or they don't trust, they might not mention, for example, that they have kids. And those are things that you want to know. And there are lots of, we have our resource about interviewing clients and how to prepare for them, and some sample questions that you can ask, and those questions are formulated with the goal of getting the information that you want from your client, as well as considering how to those healing informed interviewing practices. So now I will. So actually, let me see if are there any other questions.
There was a question asked about malpractice coverage and how that works for attorneys who might take on one of these cases. And Estelle, I thought you would be the person to address that.
I think that it falls under your right, like whatever, like regular malpractice coverage that you do have. So if you have people who are not lawyers who are participating, that's when you have to make sure you have a certain type of coverage. I have to look that up and see, but it falls under the general coverage that you would have. Well, so when I know when this is over, you're going to get an email with information, and they'll have our contact information. And so since we can't take your information, if you are interested in joining the network, and so it could either be, so if you, as an individual, it might mean that we'll also get in touch with the pro bono coordinator, pro bono counselor in your firm, but we also are going to send out cases to people who want to also just get them individually, so because sometimes I don't know how your firms, how they send around the emails with information, maybe you might miss it or something, so you can get on our list so we can send cases your way, and send you any like updates about parole in Texas that might be of interest. I'm going to stop sharing here. So yeah, so there's the support we have as part of our network. So we have like timelines of representation, checklists, letter support guides, sample packets, of course, like mentorship. And I'll show you the page. So this page, it's a password protected page. It's on TDS's website. Okay, so this is the page, and so it has all these different documents here that can help you, so like engagement letters, releases, all the different forms you need. Here's like interview topics list, for example. How to like introducing yourself, chronology. So yeah, lots of stuff there. We have sample packets. And so like you can see, for example, how like this is, has photos, little snippets of things that are relevant. What else do we have? Useful links here. It's like, for example, the TDCJ inmate information search page, where you can. So I don't want to like put someone out there. So, but when you have a TDCJ number and someone's name, it can tell you like the parole review information. So when they're up for review, when they're in the review period. What else? Yeah, and then we have this past CLE that we did. But yeah, all this stuff is available to those in our network. And really, so the main reason why it's password protected is we want to make sure that people are using it for pro bono volunteer work. And then we also actually do have on our website a public parole resources site that's mainly for like family and friends, but those are also things that like in your representation, I'll share that too, that you can use like with like family members in having them understand the parole process. So we have like a kind of video series with some short videos, FAQs, support letter guide, so even like letter support guide that's like targeted to family and friends who are working to help put together a packet for their loved ones. So we have a few minutes left. So if there are any other questions, now is when you'd want to share them.
Estelle, do you want to share the slide with our emails?
Yeah, I'm trying to get this one going again.
And I just want to reiterate, there was a question in the chat about indigent clients, how do they find legal representation pro bono? There are very few resources for pro bono representation in this capacity. TDS, the UT Parole Project really are the largest providers of pro bono legal services in the state of Texas, which is a little shocking given that we have probably about 136,000 incarcerated individuals in Texas, almost all of who will come up for parole review. So there is a desperate need for legal representation that is pro bono for these individuals. You will find family members scraping together $800 to pay for somebody to do a packet for them. But as we know, one, those packets aren't very good, typically. And two, it doesn't involve going in front of the board, which we think is the most important part of the legal representation in terms of the added bonus beyond doing the packet. The packet is important, but being able to go and actually advocate face to face with the lead voter is critical. And really, you need to be an attorney in Texas to have that privilege. So I can't emphasize enough the need for attorneys to take these cases on pro bono. And again, it is incredibly rewarding work. Are there any questions from anyone? We had a couple of questions in the chat, but
yeah, so just so I see our email addresses are here. They'll also be shared with you after. If you're interested in taking cases, we have some that we'll be able to send out to you, pretty soon after you get in touch with us. And really, what that process is, we've received questionnaires, and we kind of assess suitability, and then we send out kind of a summary of the case. And it's, if you want to take it, there's it's a conversation before. It's not just like you take it and run off. So if there are any questions that we can answer before, we go through that. And then with like timelines, a lot of it depends on, like, so if you want a case because you're like ready to jump on something right now, for example, we have something that is ready for you. If there's something you want to look at a little bit further, we also have something there for you. So yeah, so either one, just let us know. And with let's say if we have a case that is with a parole review date in June, probably you'd want to file the parole packet in April. You could, and then like between then and June, you can still supplement that packet. You'd probably have the hearing with the lead voter in probably July. So that's kind of the time range. But all of that, we could talk about when you're interested in a case. But thank you for coming, and thank you to the Houston Young Lawyers Association for helping to put this together. And we look forward to potentially working with some of you here.
Thank you, everyone.
Thank you.
Thank you.